Vanakkam. Today we are going to see another very interesting RBI circular issued by RBI recently. That is, this is RBI settlement of claims in respect of deceased customers of banks, Directions 2025. This is a very important circular. So many problems, so many clarifications have been issued through this circular. And today we are going to see that. And before going to that, I want to I want to give my disclaimer. The opinion or view given by me here in this presentation is my view. Please refer for detailed understanding of RBI circular number RBI 2025-26 82/TOR.MCS.REC 50/0.1 01.00332526 dated 26/9/2025 for clear understanding. I am not responsible for any wrong interpretation or misunderstanding based on this program. With this disclaimer, I want to start the presentation today. Deposit holders, a lot of deposits have been procured by the banks. People, they went to the bank and they make the deposit. And there are so many conditions. There are various schemes of deposits, say fixed deposit, recurring deposit, etc., etc. And they made a deposit. Yes, everything is okay, then it's fine. And also the bankers, they got safe deposit lockers and articles in safe custody in their name. For each and everything, nominee is registered. Sometimes nominee is not registered. So now we are going to have a discussion on the deposit of deceased person. A person is there, has made a deposit with a bank, that suddenly that deposit holder has died. And what is the problem? Now, the people, there is legal heir or nominee, or they want the money back. What are the rules and regulations? Through this RBI circular, it has been clearly mentioned that they say that it's an easy settlement or expeditious settlement of claims by banks. So it minimizes the hardship caused to the family members of the deceased deposit holders, because previously there was no clear-cut rules. Though some banks, they have their own rules and regulation. Now RBI has come out clearly. This is a rule to be followed in the case of deceased deposit holders. So different banks follow different type of practices. This circular easily clarifies the banks have to follow the uniform procedures in settlement of claims of deceased deposit holders of family members. And also they say that they standardize the documentation to be obtained at the time of settlement of the deposit of deceased deposit holders. The circular is useful to the nominees, because whenever there is a deposit, nominee class has to be filled. In case if there is no nominee, then what is the rule to be followed? Then nominee, it is useful to nominees. Survivors, sometimes deposit is made based on the EOS, that is either or survivor, and legal heirs. And this circular is issued by the Reserve Bank of India in the interest of the public. What is the effective date? The banks have been directed to implement the scheme expeditiously, but not later than 31/3/26. So this circular effect has to be fulfilled, has to come into full effect from 1/4/2026. So these implementations have to be made by the bank not later than 31/3/26. This circular is applicable to all commercial banks. So commercial banks means public sector banks, private sector banks, foreign banks, and as well as the cooperative banks. And to whom this circular is not applicable, that is also clearly mentioned in the RBI circular, that is government savings scheme administered by banks such as senior citizen savings scheme and public provident fund. For this circular is not applicable. The settlement under these schemes have to be made under the respective schemes. That is, if it is a PPF, then the settlement have to be made as per the PPF rules. So that then there is a threshold limit as said by the Reserve Bank of India. For cooperative banks, that is, they have to have a cutoff of threshold limit for limit up to 5 lakhs. For other banks, it is 15 lakhs. The limits may be increased or higher limit can be fixed by the bank. So with the nomination or survivor class, without joint deposit holder, there is no joint deposit, but there is a nominee, is an individual deposit, and survivor class is there. Then what is the rules? What are the rules to be followed? Bank has got a valid discharge of payment of outstanding balance in case of deposit holders, provided the bank has to establish the identity of the nominee or survivorship before by verifying the KYC. This may be physical or e-document. So, as per the direction of the deposit holder, the money has to be given to the nominee. So, the bank has to identify the nominee details, and based on that only the money can be settled. And there is no court order to restrain the payment of payment to the nominee. If there is any court order to restrain the payment to nominee or survivorship, that also the banks, they have to look into it and write to the nominees or survivorship that they are receiving the outstanding balance as a trustee. Sometimes they made the depositors have made a declaration saying that the nominee I have appointed as a trustee in with respect to the legal heirs. So the banks, they have to intimate to the nominee saying that we are transferring, we are settling amount to you as a trustee of legal hardship. But this has to be done as per the direction of the deposit holders. Now we are going for the joint deposit holders, that is A and B. So death of, in case out of A and B, one of the joint deposit holders have died with or without survivorship. So the nominee's right only arises, that is nominee's right arises only after the death of all the deposit holders. Suppose there are A, B, C. So joint deposit holders. A died. So the money can be settled only after the death of B and C. So this is the important point that you have to look into it. In case if the deposit holders wish that the legal heirs can be paid, and if it is clearly written to the bank, it is also possible. But without that, if the deposit is in the name of joint holders, so the nominee right arises only after the death of death of all the deposit holders. This is a very strict rule, and this can be modified, this can be changed by at the time of making the deposit. The deposit holders have given it in writing. We are making the deposit in the joint name. So, in case of the death of one person, the legal heirs of that deposit holder can be added and the deposit can be renewed. Or based on that, you can pre-close the deposit or you can settle the thing, but everything should be mandated in writing by all the deposit holders. Now, the bankers cease to make, that is after settlement, the banker's liability have started to cease. If all the conditions have been fulfilled, then the banker's liability constitutes a full and valid discharge. So at this time, the bankers should not insist for the the legal heirs or nominee or survivor to produce the legal document irrespective of the deposit amount. That is, you should not, you have to produce a succession certificate, letter of administration, probate of will. This should not be done. So bond of indemnity, you should not ask. Surety from anyone, you should not ask. So now the banks, now they want to make the settlement to the nominee. What are the things that the nominee have survivor of the deposit has to make to the deposit? Claim form. This claim form is also properly documented as per the RBI circular, and this claim form should be duly signed by the nominee or survivor, and the death certificate of the deposit holder, that is the death certificate of the deceased deposit holders, then KYC verification, that is for to verify the nominee or survivor, to identify and the address of the nominee or survivor have to be checked. Now, there is no nominee, then what is this is a problem. In case if the nominee is there, then the bankers, they have to make the settlement as per the nominee class. In case there is no nominee, and in that the RBI said you have to make the settlement as per the threshold limit. So the below the threshold limit, suppose in case of commercial bank, the threshold limit is 15 lakhs. Now, what are the rules to be followed? They say it's a very simplified procedure now. RBI said to settle the claims, and this is provided to the deceased depositors. That is provided the deceased depositor has not made any nominee or survivor class. So, at the time of making the deposit, no nominee is mentioned and no survivor class is mentioned. So he has left no will, and no one is contesting for the deposit as its claim, and there is no order received from the competent court. Now, the claim up to threshold limit, the banks can settle the threshold limit with interest if in case the claim form is duly signed, that is other than who have signed the letter of disclaimer or objection, then death certificate of the deceased depositors and KYC documents have to be submitted to the bank in case if it is below the threshold limit. Then bond of identity signed by the claimants, then letter of disclaimer or NOC from the non-claimant claimant legal heir if applicable. Now, the claimant claim amount is up to the threshold limit. What are the other things that he has to follow is the legal hardship certificate issued by the competent. This is a very, very basic. Because when there is a nominee, the banks, they have to make the payment as per the nominee class. In case if there is no nominee, the deposit holder died, then the deposit holder has to get a legal hardship certificate. Based on the legal hardship certificate, the amount along with the interest have to be paid by the bank to the all legal heirs or the persons authorized by all the legal heirs. The banks can make the payment. So in declaration regarding legal heirs, that is suppose in case a legal heir is not known to the bank, then the clear identification by an independent party who is well known to the family of the deceased has to give. So it's a very, very clear instruction that in case the legal heir is not known to the bank, then the person who is very close or who is well known to the bank, he can also give you a declaration saying that they are the legal heirs, and no bond of surety from a third party to be obtained for clients up to the threshold limit, that is 15 lakhs. That means it's a clear indication that if the deposit amount exceeds 15 lakhs, then bond has to be obtained. This is a very, very important thing. Now we are going for the threshold limit above. We are going to see the claim amount above the threshold limit. So here the basic point is, in case if the deposit holder died without writing a will or without mentioning anyone as nominee, then the death certificate has to be produced. KYC documents have to be produced. Then legal heir certificates have to be produced. These legal heirs have to be identified by a person who is well known to the bank. Now the limit is that is the claim amount is above the threshold limit, then the banks can make the payment. That is, they can settle the claim. That is in the form of succession certificate and documents of claim form. This claim form should be signed by all the persons who are claiming the deposit amount, and death certificate of the deceased person, then officially valid document of claimant's identity, address, and legal heir certificate issued. So the legal heir certificate is very, very important and issued by the competent authority. Sometimes affidavit shown before notary public, judge, judicial magistrate regarding legal heir of the deceased deposit by an independent person who is well known to the family of the deceased, who is not a party to the claim and is acceptable to the bank. So one thing, legal hardship certificate based on the certificate issued by the competent authority, the bankers, they can consider. And in case if the legal hash certificate is not there, then another person is an independent person who is well known to the family. He can also give you a declaration and he can give an affidavit. This affidavit should be sworn before notary public, judge or judicial magistrate. And this affidavit, if it is acceptable to the bank, then the bankers can make the settlement. Apart from above, the bank also insists for the bond or surety from a third party of individual, because if the limit exceeds the threshold limit, that is deposit amount exceeds the threshold limit, bond of surety from a third party individual, which may include non-claimant legal heirs who are acceptable to the bank and good for the claim amount. Now, one is nominee, next one is without nominee, we have made the payment. Now, next one is claims involving will, through will, and there is no dispute to the will. So first thing, if there is a will, then that will should be provided before the court of law or letter of administration. Letter of administration is nothing but the instruction given by the court to administer the property, that is administer the deposits. So after obtaining the following documents, the banks can settle, that is claim form duly signed and death certificate of the deposit holders and KYC. All this is common. So this is with reference to claims will without any dispute. There is no dispute. So first thing, you have to see the will may be registered or may not be registered. Whether it is registered or not registered, it has to be provided, and a letter of administration have to be obtained, and the claim form should be duly signed. And the person mentioned in the will, the banks have to make the payment to the person whose name is mentioned in the will. And if it is made directly to the person mentioned in the will, and if the bank settle the payment, then the bank's liability ceases. In case if any person other than the legal heir, suppose sometimes the deposits in the will, that is in the will, the deposit holder may mention the person other than the legal heir, then all the applicable documents so far we have seen have to be verified. That is, one is a deceased person's death certificate, then documents, then all KYCs, bond, everything the banks have to obtain. Now, the banks, they have to act according to the direction of will on their own. That is, the banks, they have to see the genuineness of the will. If the banks are satisfied, they can make the settlement. So sometimes if the payment has to be made based on the will, then bond of indemnity has to be obtained and it has to be duly signed by the claimants. Then letter of disclaimer or NOC in case from non-claimant of legal heirs. Sometimes some legal heirs say that I don't want money. So in that case, that non-claimant legal heirs, letter of disclaimer from the non-claimant legal heir, letter of disclaimer has to be obtained. Now, next is if it is a dispute, that is claims involving will with the dispute. Simple court order. First thing, dispute between the legal heir and beneficiary have to be clearly, that is, if there is any dispute between the legal heir and the beneficiary in the will, then both of them have to have to probate. Next one is they have to get the legal of letter of administration, succession certificate, then the court order or decree. Because in case there is any problem, that is if there is any dispute that arises between the legal heir and the beneficiary mentioned in the will, then the banks can settle only on the basis of probate of will, letter of administration, succession certificate, and court order decree. If the court order is issued, then no bond of surety is should be insisted by the bank, whether there is a dispute in will settlement or not. So now, now the bank has settled the dues of the depositors. So everything is settled. Then after settlement, there may be some credit into the account. If the credit has come into the depositor's account, then the banks, they have to return the money to the person who has remitted the money. Then these facts have to be informed to the nominee, survivor, or legal heirs. So the bank should not hold the money if it is received after the settlement in the account. Now, premature. Any deposit, if it is premature, it has to be done with the penal charges. But in the case of the deceased person's deposit holders, and the condition may be incorporated at the time of filling the term deposit application, that premature charges will not be, premature is allowed, but no penal charges will be paid by the deposit holders in case of deceased person's deposits. So now deposit can be opened jointly with or without survivorship clause. What are the important points? So premature of termination of term deposit. The consent of the surviving depositor or legal heir is first. In case the deposit is in the joint name of A or B, A died, then to pre-close the deposit, the consent of B is required. Because previously they say that in case of joint deposit holders, if one of the deposit holders have died, then the deposits amount will be settled only after the death of the other deposit joint holder. But here, premature is allowed if the consent is given by the joint deposit holder and joint account with the survivor class. That is, it's a mandate given to the bank, and deposits can be closed and settled, and settlement can be made to the survivor. But here, the concurrence of legal heirs is not required. Then sometimes a person has made the deposit, yes, is absconding or is missing, but the legal heir has got the right to get the money. And this is also clearly mentioned in the RBI circular, say that in case if there is any deposit holders, they are not able to point out or is a missed person, then the person who is claiming, that is a nominee or legal heirs, have to get the court order under the provisions of section 110 or 111 of Bharatiya Sakshya Adhiniyam 2023. Then banks have to follow the, and for this type of deposit, that is the deposit settlement of missing persons, the banks have to follow the procedures as mentioned in the case of deceased person's deposit. So before that, the court order has to be obtained for the death of the missing person. And if the deposit amount is less than 1 lakh, then copy of FIR and non-traceable certificate from police has to be obtained and the payment can be made. And sometimes the deposit is made in the name of sole proprietorship. Same rule, the persons mentioned the nominee class has to be paid. If there is no mention in the nominee class, then the payment has to be mentioned, has to be made to the legal heirs of the deposit holder. So this is very, very important. Now, a deposit holder has died outside India. He has made deposit in India, but he has died outside India. What are the rules to be followed? So here, the concept is the deposit holder has died outside India, then proof of death has to be given to the bank, and the acceptable by the bank is the original certified copy of the document as certified in the country of its issuance in any of the following modes. That is, by the authorized officials of the overseas banks or branches of scheduled commercial banks registered in India, or the branches of overseas bank with whom Indian banks have correspondent banking relationship, or court or magistrate or judge or notary public, or consularized Indian embassy or consulate general in the country of issuance, then apostille. That is the document recognized in other country. So this is the highlights of the RBI circular. That is very simple. Once again, I repeat, in case of nominee, the payment has to be made to the nominee. In case of individual, and the banker's liability is settled if they follow the proper procedures. In case of joint holders, then the death of all the joint holders, only after the death of all joint holders, the payment has to be made, but this can be ratified with the mutual consent of the other deposit holder. In case of ERS, that is either or survivor, the payment has to be made to the survivor. So if there is a will, then the banks, they have to follow the conditions mentioned in the will, and they have to make the payment to the person mentioned in the will after the will is probated. So these are the highlights, and please refer the RBI circular for your easy understanding, clear understanding. Lot of clarifications have been made in this circular. Just I explained the basic things, and there are a lot of clarifications required by the deposit holders or the legal hands of the deposit holders, nominee of the deposit holders, even by the bankers. Okay, so this is my presentation and this is my view, and I explained my view only. And I wish you all the best, members. And any clarification, you please refer the RBI circular. Thank you very much for the patient hearing of this presentation. Nandri Vanakkam.